right? So the big, huge Marvel Cinematic Universe with Captain America and Tony Stark, Iron Man, and Thor and Hulk, the biggest movie in history by box office, adjusted for gross inflation last year, Avengers Endgame, all owned by Disney. I think it's no secret that Disney owns Pixar. So Pixar, the Northern California producer of animated films using CGI like Toy Story, like Finding Nemo. And last but not least, the Walt Disney Company is also the proud owner of Lucasfilm. Lucasfilm, of course, being the production company behind Star Wars and Indiana Jones, two things I grew up on and still love watching. So long story short, all of those things were in one nice place for me. They were all on Netflix. I got Netflix content, I got great new movies straight out of the theaters, and then I got my fix of Disney content. Variety and Hollywood Reporter, two periodicals out from the West Coast in the film industry, put out an article, that's where it broke, that Disney, however, was considering putting together its own streaming service. Not even considering, they were going to do it. We now know that streaming service as Disney Plus. So starting at the end of 2019, which is now past, Disney Plus exists, Disney said, you know what, from here on out, why are we going to use this middleman, Netflix, when we could just do this ourselves? We can stream. So we could stream our Disney content. We can stream our Marvel content, our Pixar content, our Lucasfilm content, and as well as develop our own original content and put it on our own streaming service. And while that seems exciting in theory, kind of ticked me off. It ticked me off because I said to myself, well, great, now I'm set with Netflix. I have my one subscription to Netflix, but now I'm going to need two subscriptions. I'm going to have to subscribe to Netflix and to Disney Plus when it launches. Then I got to thinking one night, and I said to myself, well, if Disney's going to do this, what's to stop, if it's successful, Universal from doing it? They have content. They have a film studio. They can do the same thing. What's to stop Warner Brothers from doing this? What's to stop Paramount, owned by Viacom, from doing this, right? And eventually I prophesized in my head this really scary scenario where for years everybody had been talking about cutting the cord and leaving regular terrestrial or digital cable behind and going to all these streaming services because it was cheaper. And I'm doing the math and I'm like, look, if I'm paying $10 or more for all these streaming services to access all the content I want, because every production studio is going into business for itself, that's a problem, right? That means it's going to cost more than digital cable, where I used to have pretty much everything in one place. So cutting the cord has kind of become this myth, this urban legend. And what's really going to happen is we as consumers are going to pay more. And that in itself was troubling to me. And of course, history has proven that true, right? Recent history has proven that true. Disney Plus launched successfully in November. They're now up to, I believe, 50 million subscribers as of last week. Then Universal, Comcast decided, hey, we're going to get into business too. Let's cut out the middleman. So they are in the process of launching a service called Peacock, which I think we're going to see. It got sort of delayed, the rollout, by the COVID-19 pandemic, but we're going to see that in full force and effect at the other side. Of course, Warner Brothers decided to launch HBO Max. HBO Max will be their service because, hey, all these other movie studios are pulling their content from HBO. It's time for us to stick with our Warner Brother content and develop more content through the HBO and Cinemax brands. So we're seeing that now. And as a consumer, as I mentioned earlier, that in itself is really problematic to me and really troublesome to me, because it's just going to hurt my wallet. Then things got crazier. Okay? So we're setting up this scenario. It starts with production studios getting into business for themselves when it comes to online streaming. AT&T AT&T, mind you, is the second biggest internet provider in the United States of America, behind only Verizon. And Warner Brothers, which I've previously mentioned now, decide they're going to merge. This is known as the AT&T-Time Warner merger. And of course, it's a multi-billion-dollar merger with extreme ramifications on the stocks and on the markets. But it symbolizes something else. It symbolizes the combination of a content producer, Time Warner, with an internet provider, AT&T. So we have a content internet merger. Now, what are the concerns that come to bear when you think about something like that? Right? If you knew nothing about the law, nothing about the FCC regulations, and now we're starting to spill over into FTC, Federal Trade Commission regulations, what immediately comes to mind? Well, if I provide internet to the public, and I also own a company that develops content for that internet, what's in it for me to give Netflix a shot? What's in it for me to allow Disney Plus to run on my internet? What's in it for me to allow this new Peacock by Universal Comcast to be streamed on my internet? I don't need that. I've got my own. I want the consumers and the public to be consuming my product, Time Warner Media, HBO Max, and that whole bundle. So what's to stop me from just saying, to hell with the other guys? I'm not going to show them. If you have AT&T internet, be it on your smartphone, be it in your home, what's to stop me from blocking those things? So you can only access my content. Take that another step further. What's to stop me from making you pay more to access that content? So if you have AT&T internet, you can access HBO Max for a reasonable price, $7.99, $8.99 a month. Oh, you want Netflix though? Yeah, that's going to cost you like $70 a month. And by the way, we're going to pocket like, I don't know, 85% of that. Problem. Now, there was a safeguard in place. The problem's an obvious one, but the FTC and the United States Congress, right, had come up with a protective system to prevent that exact scenario from happening. That exact scenario that would essentially screw over consumers and then screw over other content providers, particularly smaller ones that don't run multi-billion-dollar production companies and don't have the means to compete. It was called net neutrality. There's a lot of mistruths and misinformation out there about net neutrality. Some people think it existed forever. Some people think it never existed. I'm going to set the record straight right now. Here's what net neutrality was. And notice I say was, because it's since been repealed, and we're going to get there in a few minutes. Net neutrality started as a social movement for an open and free internet in really the mid-2000s. So say like 2005, 2006, and 2007. However, it was nothing but a lobbying campaign, more or less, until about 2012. So we have a period of about 6-7 years there where all neutrality was this advocacy campaign to have a free and open internet and to adopt either legislation or regulations that would ensure that free and open internet. In about 2012, finally, the Federal Trade Commission grew a backbone, put its feet in the ground and said, you know what, we're going to try to promulgate, we call the regulation as promulgated, a piece of legislation is passed, we're going to promulgate some sort of net neutrality protection and try to enforce it. And they did. And right off the bat, it was defeated very soundly in the federal courts. The media companies went right after it and won. So what does the FTC do with support of legislators in the Congress? They go back to the drawing board and they come up with something new, right? And in 2015, they rolled out the only true official version of net neutrality that functioned as enforceable law for any period of time in the United States of America. And it began in 2015, as I said, and it really did three things. So what did we throw around again, the term neutrality? We know that it wasn't law. We tried making it law in 2012. Courts threw it out. We tried again in 2015, and this time around it was successful. But what did it actually mean? Well, at its heart, net neutrality stood for three things, and they harken back or relate back to those concerns I talked about with when you own an internet company and a content company together. The first thing that net neutrality prohibited, and this applied to anybody who provided internet, so your AT&Ts, your Verizons, your Comcasts in certain parts of the country, and so on. And it prevented them from doing something, number one, called throttling. Could not throttle internet content on your bandwidth. Throttling means what? Throttling means, let's use AT&T-Time Warner as the example again. Again, AT&T-Time Warner owns HBO, Warner Brothers, the new HBO Max service. Throttling would mean that HBO Max streams perfectly on AT&T Internet, but Netflix streams very poorly. It's interrupted, it's broken, it's constantly refreshing or loading. That would be throttling. And net neutrality prohibited throttling. The second thing actual net neutrality did was prohibit blocking. And that doesn't require a world of discussion. What was blocking? Blocking was, we're just not going to show your content in. So we're AT&T-Time Warner. We own Warner Brothers. We own HBO. We own TNT, TBS, that whole, again, bundle of content. And we're just not going to show Netflix at all. We're just not going to show Disney Plus at all. That would be no blocking. And last but not least, net neutrality, as was actually in effect as enforceable law, prohibited paid prioritization. Paid prioritization. Paid prioritization is that scenario I discussed earlier where, hey, you want HBO Max? Great. $7.99, $8.99. You want Netflix? You want Disney Plus? $70.99, $80.99. And what's more, it wasn't just about the consumer there, it was also about the content providers themselves. So in essence, by using paid prioritization, if it were permissible, these internet content mergers could double dip. They could charge the consumer, the viewer, more for use of certain services, and then they can charge actual content creators, the production studios, the content providers that were not part of that merger, money in excess to be part of their bandwidth, to be permitted to be shown on their bandwidth. So that was the last and final real tangible thing that net neutrality did. And if you look at those protections, I think they're all sensible. I think they're all logical. And I think it doesn't require a great deal of legal maneuvering or legal knowledge to figure out in terms of common sense that, hey, that works. As long as that's the case, everyone's got a fair shot, a fair shake on the internet. Great. What happens? Well, this is by no means in any way, shape, or form a political discussion. These are just facts that I'm sharing objectively. Our current presidential administration takes office in January 2017, and almost immediately starts making moves to repeal net neutrality. It was stated by the president on numerous occasions that he was not a believer in net neutrality. And I think the most profound step that was taken towards eliminating net neutrality, both figuratively and literally, was the appointment of Ajit Pai, as chairperson of the FCC. And he still is the chairperson of the FCC, but what makes Ajit Pai an interesting individual is that he had always been against net neutrality. Back from the early to mid 2000s, Ajit Pai was a vocal opponent to the concept of net neutrality. And here he is now taking the reins of the government agency responsible for promulgating regulations regarding the internet, its use, and the rules that internet providers must play by. And then it's no surprise to learn that basically within a year of Ajit Pai taking control of the FCC, net neutrality was officially repealed in June 2018, and under protest of something along the lines of 40 of the 50 states. So this was not a popular move. The way the repeal works is it was set out for approval. The states almost unanimously came back and said, we're against this. They pushed it through. They repealed it anyway. And this is all going on. The states, by the way, ended up suing the FCC for this, and that lawsuit in the federal courts is still ongoing. I don't know that there'll be a resolution anytime soon, but this is going on simultaneous to the AT&T-Time Warner merger. So here you see the problem. We have the potential for all these difficulties, challenges, and monopolistic behaviors by AT&T-Time Warner, accompanied simultaneously by the evisceration of all the safeguards to prevent that from happening. Eventually, of course, net neutrality is gone. This does wind up in federal court. It winds up first in the federal district court for the District of Columbia. That's the trial court. And at the motion stage early on, it's not like it went to a trial or anything like that. This is just attorneys making arguments and submitting papers. The judge there approved the AT&T-Time Warner merger. So essentially what happened is when you have a big multi-billion-dollar merger, federal judge has to sign off on it. An enforcement agency of the United States government might jump in and challenge that under the auspices of the Attorney General. In this case, they did, but it was a very interesting, for lack of a better term, process here, because number one, you have a administration, right, who oversees the Justice Department, and a presidential administration in the White House that oversees the Justice Department that wants net neutrality gone to ostensibly allow mergers of this magnitude and this nature. And you combine that, right, with this lawsuit, and it just doesn't add up. Why did it even happen to begin with? Was it just to save face? Is one theory. One wilder, more controversial theory is that AT&T-Time Warner, in addition to owning all the other entities I've thrown out there, happens to own CNN. And it might have been some personal vendetta from the current administration towards its favorite news media network. That's one, again, more outlandish hypotheses that's out there. But they challenged it. However, it was a very half-hearted challenge. If you go and you read the papers, one, you'll probably be bored unless you have a background in law and find the semantics and minutia of all this very fascinating. It was a very half-hearted argument that didn't rely on existing law. It avoided all reference to something we're going to talk about in a minute, the Sherman Act and the Clayton Act. It avoided all reference to United States Supreme Court precedent on antitrust, on monopolistic practices of what we call vertical integration in a business. And it was a kind of a why bother. And unsurprisingly, the district court judge at the low level of the courts approved the merger. They appealed to the circuit court for the District of Columbia. So that's the intermediate court. So we have our lower courts, the district courts. And then, of course, from there, it can go up to the United States Supreme Court. That's the final stop on the ride. So the circuit court also affirmed. They affirmed the ruling of the district court. And what's interesting is in both of those rulings, when you take the time to read them, the judges write the opinion and they say, this won't happen, this won't happen, this won't happen, this won't happen. Sure enough, all those things were happening as these opinions were being written. But what's interesting is that in this half-hearted attempt, I said there was no legal arguments. There was also no reference to this disappearance or a repeal of net neutrality, because that sort of changed the game. And the lawyers for the Justice Department didn't bring that to the court's attention. Whether the court should have recognized it on its own at either the district or circuit level, I don't know, perhaps. But at the end of the day, the good arguments were not made. The good arguments were not made. And that leaves us where? That leaves us with a situation where the AT&T-Time Warner merger can do every single thing that we said it probably shouldn't be able to do. It can make us pay more for content. That's not its. It can make us sit there and suffer through endless loading and refreshing for content that it does not own. And last but not least, it can block all content that it's not its own, and it can do so legally. Now, does this get to the Supreme Court? I don't know. I don't know. The paper that I published on this topic, before I kind of transition to how this affects the COVID-19 world we're living in now, I called it New Big to Fail. So sort of a play off of in our economic recession back in 2008, 2009, 2010, the concept of these big investment banks being quote unquote too big to fail. In other words, the government couldn't let them fail because too much would go wrong with the markets and with the economy. If they did let them go wrong, I coined the phrase for this phenomenon, new big to fail, because we're dealing with new technologies, new type of mergers, but in many ways they carry the same weight and effect, do they not? The markets are in many ways run by companies like Disney, like AT&T-Time Warner, like Comcast Universal. These are multi-billion-dollar companies that create seismic shifts in the economy when they move, right? So I called it New Big to Fail. And I considered how would the Supreme Court, especially the Supreme Court as is comprised now, where we have 4 clearly liberal justices, 4 clearly conservative justices, and a Chief Justice who is trying to play moderate for appearance's sake, but I think whose jurisprudence tends to point to him being more in the conservative branch. So how does that Supreme Court, as presently construed, rubber stamp this? If the good arguments are raised, meaning this violates the Sherman Act, this violates the Clayton Act. Sherman and Clayton are in place to prevent this happening, this monopoly, this anti-competitive practice of big corporations. And last but not least, how does this overcome the lack of FCC regulation? And there's Supreme Court case on point, believe it or not. That Supreme Court case is from 1948. It's called United States versus Paramount Pictures. Of course, the movie theaters, and we're going to address that in a few minutes when we talk about the world today and how these legal maneuverings can affect that. But back in 1948, movie theaters worked differently than they did during the era we've all lived with movie theaters in, for the most part. Notice you go to a movie theater, and the movie theater is AMC Lowe's, Regal Entertainment, Alamo Drafthouse, right? They're in other words, you don't go to Disney movie theater. You don't go to Universal movie theater. You don't go to Paramount movie theater. But let's rewind back to the 1920s, 1930s, 1940s, the start of the glitz and glamour of Hollywood and the film industry as we know it today. That's exactly how movie theaters worked. Movie studios and production companies owned the movie theaters. And what do you think happened? They only played their own movies, unless you could pony up the cash to have your movie put in there, which generally speaking, you either didn't have, or, right, you're a small content provider, small studio, so you don't have the money to get into these big theaters, right? Or they would block other studios' movies. Now, that's not how movie theaters look today, or looked right directly before COVID-19. There's a reason for that, because the Supreme Court said that is a violation of Sherman antitrust. That is a violation of Clayton. That is a monopoly, a vertical integration scheme, meaning the person who owns the means of production also owns the means of distribution, and we can't have that. So per the Supreme Court's own ruling in US v. Paramount Pictures 1948, what we have now with AT&T-Time Warner is a monopolistic entity through vertical integration that violates antitrust. It's clear cut. But again, new big to fail. We have a conservative business-based court. We have economic and marketplace needs that all revolve around this new system of streaming and content. By the way, a few things about streaming and content as an aside. Individuals between the ages of 2 years old and 30 years old consume over 80% of their content through streaming. 80% from 2 to 30. What does that mean? And the younger you get, the more they consume through streaming. What does that mean? It means that this isn't going away. This is going to be the way we consume content moving forward in the decades ahead. While traditional digital and terrestrial means see a decrease. But at the end of the day, how does the Supreme Court, if it came there, give its blessing, for lack of a better term, to a merger of this type? Well, there are a number of known antitrust exemptions from Sherman, from Clayton on the books that the Supreme Court has already decided. The first one is professional sports leagues. Think about that, right? You want to start your own baseball team in New York? You can't. Major League Baseball has a monopoly on professional baseball teams in the metro area, right? So is an internet content merger a professional sports league? No, right? And by the way, that's also a very limited exception. If you're ever interested in, you're a sports fan, you're interested about the business of sports, take a look at the Mlb Anti-Trust Exemption. It started with a case coming out of Baltimore back in the 1920s, and then carried through to Flood v. Kuhn, the big free agency case in the 70s and 60s, late 60s, early 70s. And it's a really fascinating look at how we revere baseball as a country in terms of not only its lore, but its business when you start putting the pieces together of that puzzle, because NFL has not been granted those same protections. Boxing has not been granted those same protections. So when we say professional sports exemption to antitrust, we really mean is baseball exemption. The second exemption that is somewhat applicable here would be, of course, the thought of media. There's a media exemption under two cases, the Noer case and the Pennington case. Those cases come together to form what we call the Noer-Pennington doctrine. And media exemption is sort of a misnomer, because you hear media exemption, you're like, oh, great, content, internet merger, media, boom, we're good. But no, because it's not what it seems. What the Noer-Pennington doctrine, which permits a media exemption, stands for is that businesses that would otherwise be competitive may band together and use the media to lobby for political or legislative change. So it stemmed out of these cases dealing with railroad companies and their worker unions. And basically the railroad companies got together and said, we're going to take over all this media time. We're going to pay for ads. We're going to pay for radio time. We're going to come together and we're going to run this campaign, this one-sided campaign, to put a stop to the union's grievances and the union's demands. And when they reached the court, the Supreme Court said that's okay. We're going to call it the media exemption, but it's not really truly a media exemption. And in this instance, you don't have individuals banding together, right? We don't see AT&T-Time Warner banding together with Comcast Universal, banding together with Viacom Paramount, banding together with Disney. We're not seeing that. Of course, the only two true mergers there, by the way, of the type I'm discussing is AT&T-Time Warner and Comcast Universal. We're not seeing that. They're not using airtime to lobby political. They're just making money by putting content out there. And that brings us to the last exemption, and this is where I think the Supreme Court would find that gray area where it could certainly legalize these type of mergers moving forward. So there's an exemption, never addressed particularly by the Supreme Court, more addressed by the lower courts, but it's out there, called the public utility exemption. The public utility exemption. And what that essentially means is, look, there's something out there, some utility that is so important to the public that the government itself is completely incapable of running. And because of that, we're going to grant as the government a monopoly to this private company to run this because it's of such public utility, right? A good example of a public utility monopoly that's legalized and permitted, look at no further in New York than something like Con Edison. Con Edison essentially has, I don't think it's ever been labeled as such by the courts, but it's, in my opinion, from a legal background, the perfect example of a legalized government-granted monopoly. I think we kind of find ourselves in that same situation here, right? Number one, the Supreme Court hasn't had much to say about it. It's really a combination of lower courts talking about this public utility exception. So that's number one. Supreme Court loves where it can to jump in, especially if it's an issue that doesn't involve clear political dividings, like something like same-sex marriage, or a civil rights issue, an interpretation of Title VII. Those they're sometimes hesitant to jump in on. But this I think is something they would jump in on, and they're going to say, look, we're going to take ownership now of this public utility exemption, meaning it's judicially expedient case for the Supreme Court to decide and provide clear guidance for the country on, number one. Number two, is a public utility as a definition applicable to the internet? Yeah, look at us right now. Look at the times we live in. Our entire society is completely and utterly dependent on internet bandwidth at the moment to get on with our lives, to work, to conduct business, to communicate with other loved ones, to keep ourselves entertained, to order necessities delivered to our home, because many of us are too scared to even go out to the store right now. Yeah, it's a public utility, a major, probably the most precious and valuable public utility we now have. Okay, so we have unclear guidance from the lower courts, a definite public utility. What's the last step in this puzzle? The government needs to be incapable of offering this utility itself and running and managing this utility by itself. So there is a state out there that actually tried like free, like government built and government run internet, and that was Colorado. And you want to know what happened? It absolutely failed miserably. To my knowledge, no other states have really attempted it, but I think the fact that we've only had one attempt at doing government run internet, and by the way, does that even sound like a good thing? Government run internet, right? If you want to talk about things like free speech and the ability to share ideas and opinions, when I start hearing the term government run internet, it makes me start thinking of some countries in the Far East and raising a lot of concerns. So long story short, government has not proven itself capable. So there you go. I think that is how this becomes legalized, right? And I think all those things, having to pay more for certain content, not being able to access certain content at all, suffering through poor streaming quality on certain content, will all bring itself to bear in the years to come because of the current state of the law. What could change it? Number one, we get a new presidential administration into the White House, and it's not necessarily along party lines, but just a new, fresh administration with a new approach to the internet and net neutrality. They might say, put the new chairperson of the FCC, put that back in effect. Great. The other option is, of course, the FTC, the Federal Trade Commission, jumping in. Of course, the internet and e-commerce, now more than ever, and we're going to transition to that in a second, are such a big part of our economy and our society in terms of the culture and the way we live our lives, that there's the possibility that the FTC can jump in lieu of the FCC. But what's the chances of that happening when they're all answering, all these administrative agencies are all answering to that same administration at the top. So what does COVID-19 have to do with this? Well, I said we're using the internet more now than ever. And my research focused simply on what? This one issue related to entertainment media content. But I think we're seeing very quickly a lot of, just look around, a lot of industries being completely and wholly reshaped by what's going on now. I'll give you a couple examples. Number one, the fitness and exercise industry, a huge multi-billion-dollar industry, right? I'm a member of, I do martial arts, that's like my hobby. I'm a member of a martial arts school that has multiple franchises around the country called Tiger Showman's Mixed Martial Arts. Obviously, we can't have class in the school. What are they doing? All the classes are on YouTube and on Twitch, right? It's all gone digital. My wife, same thing. She's a member of the gym Equinox, and all their classes have moved digital for their members. And it's not just the two of us. I'm seeing this everywhere throughout the fitness industry. So now the fitness industry has become really reliant on internet for more than just traditional business operations and marketing and advertising. It's how it's delivering its product to consumers. Movie theaters, right? So back to entertainment media for a second. Look what happened with recent releases by Disney and Universal. They're now doing this new thing, and they've proven to be wildly successful thus far. No, we're not even going to show them in, well, now they can't show them in movie theaters, but I think what they're going for is we're going to simultaneously release films in both a movie theater, once this is all over, and through a digital streaming service for a premium. Now, I got a few things to say about that. Number one, if you've been to a movie theater in the last 5 years, you know the experience has grown consistently more miserable. I don't understand why people pay like 20 bucks to go in there, sit on their phone and talk and take pictures of themselves. That's just me, but I will say this. COVID-19 or no COVID-19, the ability to, through my streaming services, pay 20 bucks to watch movies that are or would be currently in movie theaters right now from the privacy of my own home and the comfort of my own home seems like a really, really good deal. A really good idea, something I would really be on board for. And the movie theaters are now scared of that because the production studios are doing it and it's working. And it's working, right? So that's two examples of industries that have been changed. Number three, grocery shopping, right? It's going to be a while probably before we're all back to normal. I know I feel like I'm going out into Chernobyl when I go to the supermarket to pick up something really simple. I've got a mask on, I've got gloves on, I come home, I take off all the clothes, I take a shower immediately, especially with a very little one. I don't take any chances. So what have we resorted to? Services like Peapod, services like Uber Eats. Those industries are being changed. These services all existed in one form or another, did they not, before COVID-19, but they've taken on new meaning, new importance, and new significance now. Two more quick examples. Right now, this is, for lack of a better term, me working. Usually I'm working in front of a room full of live people in a classroom or at a conference. I'm doing the same thing right here. I can work from home. I've been doing it all semester. And last but not least, internet's been a big place for, of course, news dissemination and speech and opinion on this matter. Where am I going with all this? So we're realizing that there's all these things that can be done on the internet. As of now, we have a situation where internet content mergers are legalized, and in my legal experience, think would inevitably be legalized as a public utility by the United States Supreme Court. The question I'm asking now is what happens when, instead of merging with just Time Warner, AT&T decides, hey, you know what? We're going to merge with all these fitness companies. Or better yet, we're going to merge with Twitch or YouTube. And of course, Google and YouTube, we're going to do that kind of merger where we own all this fitness content. Well, you know what? We're going to get in bed with Target or Walmart. We're going to merge with Target and Walmart so that if you have our internet, you can only buy their products at their prices. You want some other product, you either have to brave it going out to the store, or you better find some other internet, because we're not allowing it on our internet. Things like free speech and news, right? If we're completely reliant on streaming, you own a news media company, right? You could use either example, as they're all out there, extreme to the left, extreme to the right. All the news you might get might have a significant extreme left bias and bent to it, whereas another internet provider might be merged with a news company or own a news company with an extreme right. So we're not even getting a chance to get real news and real opinions. It's all run through the perspective and preference and control of these big companies. So I guess that is my prevailing concern. I think we're seeing less of a need to do and can do things and conduct activities in life the way we used to, combined with a reliance on the internet. But very quietly in the background, based on the research I've done and now shared most of it with you, the internet's doing some weird things that can make that really problematic. Where if these internet providers, Verizon, AT&T, Comcast, start deciding we're going to do more than just our own production studios. We're going to own Walmart. We're going to own Uber Eats. We're going to own massive fitness companies. We're going to start owning all these things. Who's it going to hurt in the end? It's going to hurt individuals and consumers because they'll be tied to whatever internet provider they have in terms of their choices in life for a variety of things. And it's going to hurt our country on the whole, because I think the potential for these companies, which are all in mega mergers, which are all linked with news media in some form to begin with, are only going to allow the perpetuation of echo spheres and echo chambers, as opposed to true open discourse and the accurate, objective sharing and showcasing and dissemination of accurate information to the American public, so they truly know what is going on. Okay, so basically, that's my thoughts. That's my spiel. I'll open up for Q&A. If anyone's got any questions about anything I've discussed, anything I've spoken about today, I am very happy to take questions. If you've got a spin on this that you want to consider, please, by all means, let me know. So I think I'm not the swiftest with this technology. I tend to just use Twitter with my students. I don't see any questions, but perhaps I know Carolina's in here. Carolina, if there's a question and I'm not seeing it, because I see Caitlin Curran and Mark Andrews both popped up. Is that a question? Does Mark have? They just for some reason popped up, but I don't see any questions.
Well, thank you so much for your insightful comments in this discussion. We're all trying to work our way around this new system. So I apologize if I definitely see the hands up as well from Caitlin and Mark. So if you guys have questions, please enter them in the chat message to all participants, and Will and I can field them through, if that's okay.
And I think I do see one from Mark now. It says, not really a question, but a comment on something you touched upon. I think we lose something if everything is streaming, taking the place of movie theaters. We lose the social interaction, or at least the need to leave your home. Yeah, I agree. I agree, Mark. It's a scary, scary world. There's some very interesting movies out there. Again, I'm an entertainment buff as well as a legal scholar, that I think present some very interesting viewpoints of the world and where our world might be heading and where this COVID-19 situation may have forced it. One of them is called Ready Player One, recently made in the past few years into a movie by Steven Spielberg, where basically everyone sits at home and lives this virtual life. So you're just kind of sitting in a bedroom and everything's done virtually. It kind of amuses me in some ways that social distancing has proved so challenging for some, because we lived in a world that, in my opinion, was already, in essence, socially distanced. But I do feel people are growing more and more out of touch with one another. I agree with that comment. Let me see. I'm in this Q&A part. I thought I was. Now I'm back in the, oh, there's Q&A at the bottom. Okay. Any other questions? I'm happy to take them. If there's not, thank you for joining. Again, hope you found this.
From Michael.
Oh, here we go. Using your gym headouts, what would happen if internet provider purchased Equinox? Oh, now I'm seeing them pop up. Now they're like too fast to handle. So let me go up to Michael's. Good. Using your gym example, what would happen if an internet provider purchased Equinox? I understand how that would affect the consumer, but how do you think that would affect the gym industry? So Michael's question is, how would the purchase of gyms and other fitness studios and fitness facilities by an internet provider affect the gym industry? Here's how. I think, who are they going to purchase? They're going to purchase the big guys. They're going to purchase the big guys, right? They're not going to purchase Sam's, weightlifting express down in the corner. They're going to purchase Equinox. They're going to purchase LA Fitness. They're going to purchase all those massive brands. It's difficult enough. I happen to know a bit about the fitness industry. I've had some family work in it. It is difficult enough to be an independent in the fitness industry as it is, right? Because for all the capital investment it costs to open the place, right? Mainly, what's the biggest things? The equipment. And that equipment, by the way, needs to is obsolete within a year or two. So you're constantly re-updating that equipment. It's investment of thousands and thousands of dollars, hundreds of thousands of dollars, depending on your size, annually almost. And then, of course, marketing, advertising. How do you get people in the door? So you're bearing all these costs to begin with. And then on top of that, right, you're competing with Equinox. Equinox or LA Fitness are these multi-billion-dollar massive corporations. And to them, to refresh their equipment is nothing. Not only that, they're going to say, okay, so in order to stay in business, to make any money, Sam's Weight House on the end of the block might need to charge $100 a month, hypothetically, just to keep the lights on. Does Equinox have to do that? No. Does LA Fitness have to do that? No. They have the volume. So what you would see is two things. You would see I think, number one, I think people are going to transition to more working out online. I will say this, I'd much rather be in my martial arts studio, but there's a real convenience. There's a real convenience to just jumping down in my garage, getting it done in 45 minutes and having it over, that I don't get when I got to go take a 15-minute ride and pack a bag and do all this stuff. And I think my wife feels the same about it. So number one, I think you're going to see more of it on the internet, but the choices are going to be more and more limited. It's going to be only big name companies doing it. There'll be only big name companies, because again, if you're an internet provider, you only want to partner or merge or own the biggest and best, most profitable brands. And I think what's going to happen is the days of the neighborhood or mom and pop fitness studio or gym are going to go down the tubes. I think we're already seeing that. I think this is going to take it to the next level. So Michael, I hope that answers your question. Let me see Vivian's question. What recourse do individuals have to promote the need for protected channels for free discourse in our democracy? The recourse you have is, honestly, I'm going to say a bunch of things that sound very generic, Vivian, but it's really the only way you can affect any change in this situation. Number one, vote. Vote for candidates who are in favor of net neutrality or something similar being in place. The current administration made it very clear they were against it. Their selection of an FCC chairperson made it very clear that they were against it. So vote. Voting does more, though, than just put someone new in the White House or to keep the same person in the White House. Again, I'm not making this political. To the extent it is, it's just a factual accounting of what happened. Perhaps you think that the internet works the way it's currently construed. In that case, you vote to keep things the same, and that's fine too. It's to each his or her own. But voting does more in either direction than just putting someone in the White House and by a result, someone at the helm of the FCC. Voting also determines who's getting appointed to the courts as well. And judges of different political leanings and ideologies might decide, hey, we want net neutrality, or we're going to strike down mergers like this. Number one is vote. Number two is stuff like this can always be legislated around as well. So vote for your representatives, vote for your senators, but also lobby them, write them. That's one way we can do it. But I want to underscore too, to your question, Vivian, I've kind of predicted doom and gloom. This could all change. I mean, based on the outcome of the election in November, this could all be changed by as early as next June, or the winds can be shifting in a new direction by then. So I think it's going to be a push and pull for quite a while, but I think the current system, the current infrastructure is problematic and flawed, as I've discussed, and troubling and troublesome, to say. Additional questions? Give about another minute. Carolina, if there's anything you'd like to add about the program moving forward. Wait for any other questions before I sign off. You're welcome to do so.
Thanks, Will. I don't see any additional questions. So actually we do. Someone just popped up. Kevin Reed, here we go. How are our students reacting to online learning?
How are students, I don't see the question, but I can answer it anyway. So how are students adjusting to online learning? I think the preference, here's the thing with online learning, and this is in my experience as almost 10 years as an educator now. It's one of those things that seems great in theory, and every semester I have students saying, I want to sign up for this online class. I want to sign up for this online class. And it sounds so good, and then they end up doing it and they end up absolutely hating it. To Mark's point earlier, they miss the human interaction, they miss the engagement with the professor, they miss the ability to just ask a question, have it answered, have there be an understanding that the answer that was given was actually understandable and sufficient. They hate the tediousness of doing like a journal entry every week. So on the whole, I think my opinion of online learning is that it's a wolf in sheep's clothing, that old proverbial analogy, meaning it seems so good in theory, but in practice, it's just not very effective, very tedious, and not preferred. And I've seen that time and time again. Now, in terms of this semester, I think, as is always the case with our St. John's family, I think the students in that spirit are really making the best of it. I think it varies from class to class and course to course, how students are faring with it. I think it varies based on their home. To give a very candid take, it varies based on their home situations. We need to remember the diverse makeup and background of our St. John's student body and realize that some of our current students come from very underprivileged and underrepresented backgrounds where the most effective environment for them to learn is actually on campus, directly with their peers, directly with their professors in that environment, as opposed to whatever they may be accustomed to or dealing with in their home. So there's that. So I think it's been a work in progress. I don't think it's been perfect, but I think students have been up for the task. I think most faculty have been up for the task. And to throw in my kind of final opinion on the matter, what I did is I said this WebEx technology is new to me. I don't use it. I don't like having to learn new things. I know how to use Twitter. My students know how to use Twitter. So I've actually conducted my whole semester since we've moved to distance learning on Twitter. And look, it's one instructor, one faculty member. I can't speak for everybody, but my anecdotal feedback from the students has been it's a much preferable method. And I find that interesting that all these resources are put into these really fancy remote distance learning tools. And at the end of the day, you can log on Twitter, go live, and to the students, that's much more effective. And it's not surprising, it's where they are. So I think it's been a challenge. I think the students, it's been a challenge with many micro challenges. The students are up for the challenge. The faculty are managing it as best we can. And I think at the end of the day, the thing that keeps it successful or somewhat successful, and it's making it work, is when people start getting creative and doing more than simply posting assignments on Blackboard. And that's my answer.
Thanks, Will. We have one more question from Randy Gonzalez. Actually, a couple more, I think.
How come, like, I'm not seeing these, but I see Randy's actually. What are the chances of the baseball exception you spoke of getting overruled? Slim to none. The only way, Randy, that would come up is essentially you or I or anybody would have to say, we need the case to make it happen. You need a case to make it happen. So it would require, it wouldn't be you or I. It would be some multi-billionaire out there who says, you know what? I want a Major League Baseball team. I'm going to start a Major League Baseball team, and doing it and then getting sued by Major League Baseball. So in other words, we would say, you know what? We're going to recreate, hypothetically, let's use New York as the example. We're going to recreate the Brooklyn Dodgers. A bunch of billionaires get together. We're going to build a stadium. We're going to start the team, and we want to do Major League Baseball. And one of two things is going to happen. Either Major League Baseball is not going to let them in, and then this new Brooklyn Dodgers organization run by a bunch of billionaires is going to sue Major League Baseball, and the court would have to get rid of the antitrust exemption, or they would have to be let in the league, and who would be doing the suing then? Major League Baseball let them in, so it wouldn't be Major League Baseball involved in the lawsuit. It would be the Yankees and the Mets probably suing Major League Baseball for letting in this new Brooklyn Dodgers franchise. The chances of that happening, I think are very slim. The culture of sports business is such that it is truly the stereotypical old billionaire boys club, you can't just start a team. You got to know the right people. They need to invite you to start a team. So I don't think the chances of that happening are particularly high, but that would be how it could happen or would happen if it were to happen. Other questions, Carolina? Anything I'm missing? Maybe they're in the chat. Maybe that's why.
I haven't seen anything pop up on the chat.
Okay.
So I think that's it for questions. Will, thank you so much for your insights, your knowledge, and obviously just for being a partner of alumni relations and always coming to the rescue in every possible scenario. To our alumni who participated, you have been amazing. We're really excited to continue to bring these to you. Hopefully every month we'll have a different faculty member and topic to cover each time. We're all working again through the kinks of technology, but hopefully this was a seamless experience for you. We have a short survey at the end, if you wouldn't mind filling it out, just so we can learn how to improve. And that's it for me. Thank you so much for your time, everyone. Will, I'll give you the final word.
Hey, thank you guys so much. Again, hope you enjoyed it. I hope it got you thinking. And even though we're talking about some topics which are related to what's going on around us, I hope it got you thinking about them in a little bit of a different way, something new to consider besides just a tragic number on the screen. I hope, again, you guys all stay involved and active. The best thing about St. John's ever since I started working here is it really is a family. And the alumni are sort of in my opinion, one of the most important parts of that family. So great to keep you guys engaged. I hope you enjoy the additional lectures to come. And most importantly, I hope everyone stays very safe and everyone stays very healthy as we get through this. And we certainly will get through this. So with that, I am going to sign off. It's been a pleasure. And I hope to see all of you in person at an alumni event, hopefully in the really near future. All right? Take care.